All right, now, so today we're all here to talk about the RCSD, representative capacity. So let's look at the paragraph that deals with that. So if one or more parties signing this agreement in a representative capacity, what is that? Does somebody want to define representative capacity? Like pretend I'm 7 years old. Sorry, making faces behind me. Pretend I'm, well, 8. The 8 is smart enough to understand that. What's the concept of representative capacity?
Well, like in my case, I'm doing a probate sale,
Okay.
so the executrix is not the seller, but she is the authorized representative to sign all the documents.
Okay. So they know, and executrix sounds a lot more exciting than it actually is. Don't worry about that. It's the decision maker for somebody other than themselves. We can all sign for ourselves. But if we're signing for something other than ourselves, then we're representing them and we have a legal capacity to do it. Good. So what are some instances? Well, we'll get into that in a minute. Okay. Then the party needs to indicate on paragraph 3132 and attach a representative capacity signature disclosure, which is what we're going to go over today. Wherever the signature initials of the representative identified in the RCSD appear in this agreement or any related documents, it will be deemed to be representative capacity of the entity described. Now, we run into some issues with zip forms and your contract because the true way, the correct legal way to fill out these contracts is to have the entity as the buyer, and then the signer needs to be somebody different. I've spent a good portion of the last 2.5 years as your broker trying to get them to release that lock. If I can, and I get apoplectic about this, my brain wants to explode. If I have the legal obligation and the wherewithal to be able to help people buy multi-million-dollar property, then I for sure should be able to modify this contract such that an attorney would review it and think that it was done well, right? I don't want to look like a dipshit when I'm talking. Dang it, I did it again. I don't want to look like an idiot when I am taking this contract to the attorney for the probate and I can't get the contract filled out correctly. Unfortunately, zip forms won't allow us to do that yet. That can be one of my, if I join the forms committee at the MLS, then I'll go fight that good fight. How's that? So what they've done, and in the contract, any place where the seller or buyer signs in a representative capacity, even if they don't put comma president or comma trustee or whatever it is their title that's part of the signature, it's deemed to be in that role. Okay, if you're using the RCSD. The party acting as a representative capacity, in a representative capacity, represents that the entity for which they are a party is acting already exists. Don't write an offer in an LLC that doesn't exist. They all want to do that. These investor guys want to, oh yeah, we're going to create the LLC as soon as we open escrow. No, has to exist first. And they need to deliver to the party, the escrow holder, within 3 days of acceptance, evidence of authority to act in that capacity. So an LLC or a corporation will have a page in it. They don't have to give the whole articles necessarily, but there will be a page in there that says the president and secretary treasurer both have the option, the ability to buy and or sell real estate. Or the court will have a document for probate that says the executrix is able to act on behalf of the estate and sell real estate. Letters, testamentary, court order, power of attorney, corporate resolution, or formation documents of that entity. Okay, so that's what that is. The document, yes, Tony.
I think one thing that maybe everyone needs to also be aware of is that you can have that original, let's say, trust document that gives permission to Tony Debs as trustee, but then unbeknownst to you, the listing agent or whomever, there was an addendum. Yeah. An amendment to that trust. So that would be a question you really need to ask is, and have there any, I mean, I think escrow asked that, but I don't know that I did when I didn't know.
I haven't either. Yeah. A lot of times when you're in a listing agreement, this isn't necessarily a listing class, but it comes up. It's like, oh, I own it in a trust. You say, do you have the trust documents? Oh, no, we don't have those. You're going to need those when we open escrow. Just keep going here, sign here, press hard. That's what'll happen in real life. You should see them, you should put your eyes on them, you should, but I mean, I've read a number of trust documents, some of them, I mean, I don't want to go through them and go, oh, this is done wrong. Ooh, right? I don't want to be the whistleblower on that. I want escrow to do that. I want to be in escrow by the time we get to that point. And then we can clean it up, we can fix it, they can go meet with another estate attorney and get it redrafted, they can do whatever they got to do, but I don't want that to keep, I don't want them to go, well, we got to meet with an attorney and we'll see you in 6 months. And no, get it on the market. This is being recorded. All right, what you have in front of you, the packet. Do you have a packet? Molly, will you facilitate for me, please? What you have in front of you is a packet. The first page is how they sign in their representative capacity, and then each page behind is the actual RCSD filled out properly and signed properly for each scenario, okay? So the first one is trust. We see this most often. With or without a trust addendum or trust advisory in your packet, they're going to sign on behalf of their trust. My mother-in-law is selling her home. She has a property placed in trust for estate planning purposes. It's owned by a trust. She is the trustee. She has the right to be able to sell that. This is how she would need to sign as trustee. So you either put TE, TR would work, comma trustee. That is part of your signature in your role as the trustee for the trust, which is the Kate Graham Trust for the benefit and support of little old ladies, dated January 24, 2001. That's her original trust that she's established for our scenario. Is somebody, will you kill it? She's going to sign Kate Graham, comma, trustee. So you just put TE, capital TE works, any of those. Just add that TE on there. It is a pain, and you're going to have to walk them through it, but their signature is incomplete, technically. We need it, at the very least, you need the comma trustee on the RCSD. On the rest of them, you can kind of let it slide a little bit. I tend to be a stickler on that kind of stuff. I want to make sure it gets done right the first time. So we go back. Make sure too that your TC, if they're helping you fill in your DocuSign, that the comma trustee or that the role of trustee, it gets noted in there as well. So when they go through and sign it, it's part of that.
On the initial throughout the document?
You don't have to do initials. It's just their initials as an individual. But they, the actual signature is what commits them to whatever they're agreeing to. And so that's where you can initial and never sign, and you're not necessarily committed. Initials are just proof that you had an opportunity to review that particular page. Does that make sense? So it's sort of an acknowledgement rather than a commitment. So that's for the trust, and we'll see that form filled out when we get to the next one. If you're signing for an LLC, partnership, or a corporation, you're going to sign in your role or capacity as that. So Kate Graham, comma, president would be a corporate signature. LLCs are all members. You could be also a managing member, potentially MM, but you would sign Kate Graham, comma, member, and then partnerships would be comma, partner. In that case, power of attorney gets a little bit sticky because it's a durable power of attorney or a specific power of attorney with regards to the dissolution or resolution of real estate is rare that the courts will grant that for true power of attorney to be able to sell real estate. If they come out of their coma and you sold their real estate, there's going to be a lawsuit, and the courts don't like to be the one that granted that, right? So it's going to be a rare instance that you'll see that. But there are instances of incapacitation, or they're deemed, what am I looking for when they're deemed, yeah, that there's another thing too, like if they're, yeah, like that. And I had a client of mine that had early stages of dementia, and he had signed a power of attorney, but by the time we closed escrow on his short sale, he was still lucid enough to be able to sign everything. So he signed on that, but his wife could have, had it gotten worse, she could have stepped in and signed as power of attorney. So power of attorney, you're going to sign Kate Graham by, and then the name of the party that you're signing for, comma, POA, power of attorney. It's a long signature. It's a pain. You're not going to sign, you're not going to forge their signature. It's your script. So I would sign Scott Taylor by Molly Lannon, because Molly's incapacitated. Sorry, Molly. Comma, POA, and then date it. And you've got examples on each of these coming up. Estates and probates. So you're going to be the estate of Kate Graham, case number SOCAL, SoCal 4877, blah, blah, whatever. So is your probate kind of the same way?
Yeah.
Okay. So you have a case number that's assigned by the county and it's managed that way. You have a judge that's assigned to it. They'll review all the documents. You got to go back and forth and review the offers. Part of the probate process is that the estate needs to pay for an appraisal. Sometimes they need to pay for 2 appraisals because they set up an appraisal when the decedent actually passed, and then now we're trying to sell it, so we need another one, or an updated one. So there might be more than one appraisal. There are some rules within probate. So if you're doing a probate deal, you're going to want to talk to me. You're going to want to talk to Tony. You're going to talk to Stacy, Scott Hagewood, any of the broker support folks that we have here, to make sure that you're filling out the paperwork correctly, that the contract gets done right, and you'll want to kind of help you manage that transaction as it goes through. It's a complicated process. They have a limited window of what they can accept. The judge is actually limited. I think it's 10% within, plus or minus 10%.
Yeah,
Is that right?
90%
90% of the appraised value. And sometimes in a downwardly moving market, or you get an overly zealous appraiser that thinks they're doing somebody a favor by valuing it higher than it actually is worth, whatever. So there's some complication there. Go ahead.
Like we do a bunch of justice domains, and a lot of times we'll just waive the appraisal. Still coming up for offer. It could be like $30,000 over asking price.
Oh yeah, okay, yeah. I get it.
Waived because is that why?
If you're gonna waive your appraisal contingency,
Yeah.
the court still has a requirement, but it's easy for them. They just look at the appraisal and go, the offer's above that, check the box, we can move on. It's when it's lower than the appraisal, they have to stay within 10%. The court would love for you to come in higher. Yeah, good point. So executrix, again, not as exciting as it sounds. It's just a lot of responsibility. So here's what the representative capacity disclosure looks like. It's very similar. This is the -S. If you see up here, will this highlight? There it is. RCSD-S, it's for sellers. If you've got a buyer, you want to use the -B version. It's more rare for us to see them, to fill these out for buyers, mainly because if there's a bank loan involved, the banks don't like to lend money to entities for residential real estate purchases. They want to lend money to a human that they can chase down and force you into bankruptcy. So it's harder to bankrupt a trust. It's possible, but so if your buyer's filling out a representative capacity as a buyer along with their offer, they got the cash most likely in the bank account of the trust, and that's the question that you need to ask. Yes, you have the cash. Is it all in the trust account? And they say, yeah, most of it. Okay. Can you get it out of the investment account personally and put it in the trust so that the trust is the one purchasing it? Because if you're doing part of the money from yourself and part of the money from the trust, guess what? We now have one person purchasing our property in 2 different spots. So Nicole loves these. Everybody know Nicole? This is who reviews your files. This is, if you don't get your check, it's your fault, but she's making me aware of it. How's that? So you want to make sure that they have the money. So if they're buying it on the buy side, that's why we do this on the sell side, because we see those more often. Most often people will purchase a property and then for estate planning purposes, move it into a trust or a corporation or whatever. On the buy side, we don't see it very often. It's the same thing. You fill it in, it's the Kate Graham Family Trust. The name of the trust is the Kate Graham Family Trust for the benefit and support of little old ladies, The full name of the trust would want to go there. It does have, so you're checking the box for trust, because that's where we are right now. And the form has changed a little bit. It used to have the date of the trust that was here, but now we just put that in the name. We're going to skip over B, C, and D because we'll talk about those next. Then, of course, she signs Kate Graham, trustee. Again, she could also use TE. You could probably get away with TR. You could probably just get away with T, but let's just stick to it, right? So we've got title as trustee, or let's see, will this highlight? Oh, dang it. So she put this down in the title. I can't highlight on this form, but it says trustee, TE or TT, and that works for trustee. Then if we're doing it at time of listing, you're going to fill it out here. for the brokerage that you belong to. If it's later at time of sale, you're going to fill it out down below. And then if there's another agreement that you're dealing with, this is a disclosure that goes to all parties involved in the transaction that they are signing as a representative of a particular entity. That's it. Beyond that, just a disclosure. Next one is Such a Nasty Woman, Inc. As you see now why I use Kate's forms. It's entertaining, keeps it lively. So she's signing as an entity. She's checked the box for entity, checked the box for corporation, and the resolution is not attached. And again, you've got copies of this. You want to hold on to them. It's important for you to just make sure that those boxes get checked when you're dealing with an entity. Again, if you do have the corporate resolution, you're not going to check that box because you could potentially attach it. Kate Graham, president, she's the pres. You can also, if the resolution, corporate resolution allows the vice president or someone else to sign, you can do that. They don't have to be the president to sign. You just want to make sure you put their role because that is part of their signature. Same thing on that. Next one is power of attorney. Again, extremely rare. Has anybody here, I actually have somebody who might, has anybody dealt with a power of attorney sale before? Tony, you have?
I did, but then it took 2 doctors to prove it, so.
Whew. Okay, so yeah, extremely rare. You're gonna wanna bring your broker in on it if you've got a true power of attorney, buy or sell, because it's gonna get hairy. Yeah, like she just said, 3 attorneys involved.
3 doctors.
Or 3 doctors, excuse me. Yeah, well, them 2. Power of attorney, sellers or principal authorized to sign below. It's a general power of attorney or specific power of attorney. If it's specific, it's for a limited time period. And so it'll have a date on it. And it'll be court order, court action. So there'll be some sort of legal document. It'll probably have an official stamp and the judge will have to sign off on it. And again, you're going to sign, or she, whoever our party is going to sign their name and their signature, comma, and then by blah, 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 blah. Power of attorney.
I want to say that, excuse me for interrupting.
Did I back up?
I
No,
wanna
it's fine.
say that, I don't know if it was First American or Fidelity, would not accept a general power of attorney. It had to be a.
It had to be specific.
So-
I feel like I've heard that too.
Yeah, so if you,
Yeah.
even though this contract says that, if you're going to use Fidelity or First American or any, you should check with them, because I remember that clearly when we were trying.
Good
to do
point.
this.
Yeah, again, you're going to want to bring your broker in. You want to have, this is one of those instances where your escrow company, your escrow officer and your title officer is vital. In fact, I would recommend not using Central Coast Escrow and just going to the title company. If you like the Fidelity or First American or Placer, use their escrow officer so that they can all talk to each other. Insurance is going to be seamless. Everything's going to be not a problem. You don't want to split those up on a complicated transaction like that. Don't tell Jay I told you that, but this for safety's sake. For safety's sake. Okay, last one is the estate of. So the state can be in, you can be estate or conservatorship or guardianship. Again, really rare. You can be the estate of, right? So the Hearst family has all of their estate. They've got, I'm sure they have layers of trusts, and this is probably where you're going to have an attorney or a trust advisor. We use trust differently in the legal world than we do necessarily in the real estate world. So you could have someone be a trustee of a family trust, right? My wife Teresa and I are trustees of our family trust. But then if we get a huge estate and we die, and then some law firm is going to manage our estate for us, they then can act as trustee or in trust based on our instructions, whether or not our assets were in a trust or not. Does that make sense? They get paid a fee to manage our stuff for us. And that's trust, but it's not a trust. It is different than that. If you get into that world, well, again, call your broker. You're in over your head is what's happening there. So she's going to sign as executrix because she's on behalf of the estate of Kate Graham. Such a nasty woman. Oh, I've got another one. Blank.
That one's a buyer.
It's a buyer.
Oh, these are the buyer ones. Okay. Igor, Dylan Weed is selling. Love it. Okay, so there's a buyer one. It's the most common buyer version of this is buying on behalf of the trust. They sold something in some other area, they've got trust money and they're gonna buy it, cash is in the trust. So my mother-in-law's my example on that. She's selling her home. She's gonna go buy a home in another place. All the money is getting wired into her trust account and she's gonna use part of that money to buy a house, all cash on the other end. And that's what they would have over there. Okay, so that is it for the RCSD. I'm gonna stop our recording here. Bye, guys. Stop the recording. Now we can go back to swearing if we want.